Today we'll be looking at the Duhig Rule. This is one of the most confusing and frankly most controversial cases in oil and gas law. And it's relevant to us as land professionals because it's a guide for constructing how you interpret warranty deeds and special warranty deeds when there is what we call a double fraction or an overconveyance. So sometimes this is called the double fraction rule or the overconveyance rule. So when we say double fraction, what we're saying is if someone owns a half, or it doesn't have to be a half, but any fraction, and conveys a half and reserves a half, they convey a half and they reserve a half, that's one fraction, that's two fractions. That's a double fraction rule. And then the other one is overconveyance. And an overconveyance is when you have party A owns 50%, party B owns 50%, and party B conveys his 50% to C, but reserves 50%. So if you add this up, it's 50 and 50 is 100, is 150. You can't have that. You can only convey 100% of your interest. So now we have a 150% interest. That's called an overconveyance. So the Duhig Rule is how you interpret these types of deeds when you have a double fraction or an overconveyance. Now, this case is relevant to us as landmen, which we will run across it when we're running the chain of title. It's also relevant to title attorneys if they're preparing the title opinion and they run across a deed that has this double fraction or this overconveyance in it. That title attorney needs to know how that jurisdiction interprets that kind of a deed. It also applies to division order analysts and lease and title analysts when there's a change of ownership and you're trying to determine, you find this kind of language in the conveyance deed or the instrument of conveyance. It's also relevant, even though it's a 1940 Texas case, it's been followed in most, if not all, of the oil and gas jurisdictions. It's been followed in Texas, Colorado, Oklahoma, New Mexico, Wyoming, Louisiana, Mississippi, Alabama, and Arkansas for sure at the present time. And, laws change, so you have to stay up with this in the state that you're in. Now, this is a very confusing rule, and my goal here today is to simplify it so that when you read the many erudite articles on this topic, in researching this topic, there were many fantastic articles. But what I want to give you is just the foundation, the gist of the case, so that when you read those more erudite articles, you'll have a good handle on what the case itself says. So let's look then at the facts in Duhig versus P.V. Moore Lumber Company. And it starts with a man named Gilmer. Gilmer owned 100% of an interest in Orange County, Texas. Gilmer owned 100%. And Gilmer conveyed to Duhig, he conveyed to Duhig 50% of his interest. So now Duhig has 50% and Gilmer has the remaining 50%, 50%, 50%. We're at 100%. Okay? Everyone understands this part of the case. This part of the case is crystal clear. What gets more confusing is that Duhig then conveys to the lumber company 50%, but he also accepts from this, he reserves unto himself a 50% interest. So most of us would look at this and say, okay, he had a 50% interest. He's conveying 50% of that 50% interest. So the lumber company is going to end up with 25%. Duhig's going to end up with 25%. And Gilmer is going to end up with the remaining 50%, which equals 100%. But that's not what the court decided. The court decided that the lumber company would get this full 50% and leave Duhig with zero. So Duhig here is suing the lumber company for what he believes is his balance due to him. Now, this may seem ridiculous to us, but keep in mind that you and I both know that Duhig only owned a 50% interest. But the lumber company's argument was, wait a minute, we thought you owned 100% interest. If you own 100% and you convey 50% to us and you keep 50%, then we would get 50% and you would get 50%. But our assumption is that we're getting 50%. And I think that's a reasonable assumption. If the deed does not clarify that there's any prior reservations, it's reasonable for the grantee to think that they are getting 100%. So what the Duhig Rule says is that if there is a conflict, between the granting clause and the reserving clause, we're going to satisfy the granting clause first. So we're going to give priority to the granting clause, and then if there's anything left after that, we'll give you whatever you reserved. A baseball analogy: if you grant and convey something in a deed and reserve something in a deed, and there's a conflict between what you granted and what you reserved, in this case, you're reserving 50% and you're conveying 50%, but you only have 50%, tie goes to the granting clause. The granting clause is going to trump the reserving clause. So the court said, well, in the granting clause, he's granting 50%. He only owned 50%, so he's granting his full 50% to the lumber company. Now, the fact that he reserved 50%, well, he didn't have 50% to reserve because he only owned 50%. So we're going to give weight to this and we're going to disregard this. And that is how the court ruled. So the final ownership then was Gilmer 50%, Duhig 0, and the lumber company 50%. Now those are the basic facts of Duhig versus P.V. Moore. But look, the court could have decided this differently. The court could have said, you know what? It's your responsibility, lumber company. It's your responsibility to go back and check and see if this person had any outstanding interest. The court could have said, we're going to give plain meaning to it. He had 50%, he's conveying 50% and reserving 50%. Therefore, lumber company, you get 25, he gets 25, and Gilmer gets 50%. All right. But the result of that would have been the burden would be on the grantee to figure out what the grantor owned. Now, as someone who runs title, I like the fact that they have to disclose what their interest is in the deed, or Duhig will apply. Because I want to see, as I go along checking my title, I want to see if what is in these deeds is matching what I'm finding, is matching my conclusions, basically. So the court says, well, if there's a conflict between the granting and reserving clause, tie goes to the granting clause. But what they're really saying is, all right, Duhig, if you really wanted to convey 50% of your 50%, then you should have told them. You should have said, hey, I only have 50%. Clear drafting will avoid the Duhig Rule. And to the extent that the Duhig Rule encourages good drafting, I think it's a good rule. And I think that's why it's been followed in so many other jurisdictions. Now, the other thing that can be proved is that if the lumber company had actual notice, if they knew, like you and I knew, that he only owned a 50% interest, then he can't claim Duhig. But as many of you know, it's very difficult to prove if someone had actual notice. We can prove constructive notice because they could just go back through the county records and find out how much Gilmer owned, how much Duhig ruled. But the test is, do you have actual notice? And if Duhig could have proven that the lumber company had actual notice that they were only getting 50% of 50%, he would have been successful. So even language like this interest is conveyed subject to existing reservations. That's enough to defeat Duhig. Now we're putting the lumber company on notice, hey, you know what? There were some existing reservations here. There were some prior reservations here. Another thing we could say is that we could say accepting all previously reserved interest. Now the lumber company is on notice that there were previously reserved interest. So they're gonna have to know, based on the instrument and the deed, that they were only getting that they were not getting 100%. So let's just for a second look at the actual language of the court itself. The granting clause says that I hereby grant, bargain, and convey the land described as that certain parcel of land in Orange County, Texas, in the Josiah Jordan survey. And then it gives the certificate number followed by a metes and bounds description. So he's basically saying, I am conveying the land. Doesn't saying my interest in the land or what his interest in. And then he goes on to say, but it is expressly agreed and stipulated that the grantor herein retains an undivided 1/2 interest in and to all mineral rights. So this is the this is the granting clause, which said basically all interest in the land, and this is the reserving clause. So as the rule states, if there's a conflict between the granting clause and the reserving clause, tie goes to the granting clause, and we're going to fulfill that first. So the bottom line is, these are the red flags when you are trying to decide whether Duhig applies. First of all, is there a double fraction, the half of half, or half reserving half, I'm sorry. Is there an overconveyance where someone gives 50% and keeps 50% and they only had 50%? That's going to be your first clue that this might be Duhig. The second is this a warranty deed or a special warranty deed? That's the only time that Duhig is going to apply. It does not apply in a quitclaim deed. It does not apply in an oil and gas lease. And the third question is the prior interest disclosed? Is the prior interest disclosed so that the grantee will have noticed that the grantor owned less than 100%? If you answer yes to all three of these, then there is no Duhig issue. But if you responded yes to question 1 and yes to question 2 and no to question 3, that the deed was not disclosed, Duhig will apply and the granting clause will be applied first. So the first question is there a double fraction or an overconveyance? The second question is this a warranty deed or a special warranty deed? And the third question is the interest disclosed? Those are your red flags that are going to let you know if the Duhig Rule applies. I hope that this was helpful. This is, in fact, the Duhig Rule in a nutshell.